Hey everybody, welcome back to Guns and Gadgets, your premier source for Second Amendment news. If you're a regular viewer of this channel, you know I've been burning the midnight oil. I've done 6 videos in the last 2 days. I'm hoping today is a little quieter, but I am hoping this video will prepare you for just how important this Friday is related to the Second Amendment and federal cases sitting in front of the United States Supreme Court. Yesterday I had a really cool conversation with one of my friends who is an attorney, and we get along pretty good, and I really like when we go back and forth because we kind of see things the same, but it's always great to see somebody else's point of view because it makes you kind of, oh yeah, I didn't think of that type deal. And we were talking, and we both were under the agreement that even though we had a couple setbacks recently here, the second, specifically the SCOTUS case with New York State Rifle and Pistol Association, that's probably not the best case that we want, and we as Second Amendment supporters, that we want to determine how the rest of the nation's courts look at or determine cases related to the Second. And, you know, immediately when the Supreme Court, or any court for that matter, takes an action against anything that an individual feels is important, that person is going to feel dejected, upset, etc. So the rest of us, you know, all of us that out there are pro-gun, pro-2A, we're kind of pissed off when the Supreme Court said it's moot, we're not going to listen to it, so sad, too bad, right? But when we drill down into these cases, it's probably not the best one, like my buddy Dave said. Probably not the best case that we want in front of the Supreme Court to determine this stuff, because the Supreme Court is famous for doing like one swipe. All right, we're gonna set this record straight with one case. Let's do it, and we'll make this, you know, a representation of how we feel, and we're gonna remind the nation's courts this is how it should be. When you look at the New York State Rifle and Pistol Association case, were the people in New York screwed with? Yep. Did New York play the court kind of like a fiddle by changing the law after the fact that the court took it up? Yep. But is the rest of the nation facing those type of restrictions? No. And while it might suck for the people in New York to hear that, it's true. So that would only affect a small amount of people. There's 10 cases in front of the Supreme Court for the conference on Friday. I have all 10. I'll give you a quick rundown of each one of them, a sentence or two, so it's not going to be a very long video. But there are definitely some in here that you want them to take up to remind the rest of the nation's courts how it's supposed to be. That is, of course, assuming, never make an assumption because it makes an ass out of you and me, but that is assuming they do their job. And I'm also, if you look at things in hindsight, you know, they always say hindsight is 20/20, but if you look at things that Justice Kavanaugh said, that, you know, he was a little upset, didn't agree with them dumping that case this week. However, he hoped that the court took up a Second Amendment case soon. He knew there was 10 cases being looked at Friday for conference. So I hope, well, the theme for Friday is big. It's basically assault weapons bans and how states who are not shall issue, how they determine who gets a permit and why. And there are a lot of cases here of those 10 that are surrounding those 2 points. And so that makes me think right there that there's probably a good chance that we're going to get something solid Friday that they elect to take up. And of course, if you want to stay tuned with that, you need to subscribe to Guns and Gadgets. This is the premier source of Second Amendment news, and you will find it here, okay? So thank you, and I hope you stick around, and welcome to the channel if you're new. So of the 10, there are a couple here that are near and dear to my heart, and you'll see why when we get to them. But these are the 10 in no specific order of importance, just what the cases they're going to be contemplating on Friday. So the first one is Wilson v. Cook, and that is an Illinois case, and that looks to challenge the county commissioners, or the commissioners of the county, however they say it out there, but the commissioners of Cook County. Now, if you remember this channel and you watch regularly, you'll remember that Cook County banned assault weapons and high-capacity magazines within the limits of the county. So it's a ban of commonly owned arms. Okay, do many people in the country own ARs? Yes, it's the most popular rifle, semi-automatic rifle in America. followed number 2 by probably the AK. And those are what they want to ban, and they're commonly owned. Are standard capacity magazines that come with the weapons, are they commonly owned in the US, or is it something special? Nope, they're common. I'm saying that for a reason, because those are the terms that are in the United States Supreme Court's DC versus Heller decision, that commonly owned arms cannot be banned. And it's not up to a court to decide what common is. It's the fact that they're commonly owned. However, with this balancing test that the lower courts have been doing for the last couple decades, they're finding their ways around it, okay? But the fact of the matter is the standard for the country in DC versus Heller is that commonly owned arms cannot be banned. Yet Cook County did that. So that's one of the cases they're looking at. And again, that is Wilson v. Cook. Case number 2, again, random order, is Culp v. Rowell. And Culp v. Rowell is another Illinois case. But this time it has to do with their permit, the carry permits, and how non-residents, people who don't live in the state, are not allowed to apply for them regardless of their training, knowledge, qualifications, etc. Here in Massachusetts, if you live in a different state and you want to be able to carry here in Mass, so you come here for business or whatever, you can apply. It's a crazy amount of money. It's a stupid system. However, even Massachusetts allows non-residents to apply. So that is the second case from Illinois that has to do with permits. And again, that is Culp v. Rowell, or Raoul, R-A-O-U-L. Case number 3 that they're going to contemplate on Friday is Mance v. Barr. And this case challenges the interstate ban on handgun sales transactions. Now, this was established way back in 1968 under the Gun Control Act of 1968. And since then, if you live on a border, like I live on a border town of this 3 states in my corner here, and I couldn't go 4 miles to the south into Rhode Island and buy a gun and bring it into Mass. Stupid. You can buy long guns from other states. And there are a couple other requirements you have to do, but you can't do that for pistols. So that is being challenged, Mance v. Barr. Another case we talked a lot about on this channel in the last couple of years is Pena v. Horan. Pena v. Horan, this case comes to us courtesy of Kamala Harris. Kamala Harris, the AG of California, was running for president and is working hard to be Biden's vice president. But this has to do with California's microstamping law and the handgun roster. California's microstamping law requires that any new handgun sold in California has to have technology in it that does not even exist. For every time you pull the trigger, the case that's ejected from the firearm would have to have microstamped numbers, characters in it, but each one would have to be unique, individual, and separate from the one before it. There's no way that technology exists. And again, that would fall under DC versus Heller, because this effectively bans all new firearms, okay? All new firearms, because nothing can do that. It is a ban on commonly owned arms. You definitely can see a little theme here, okay? So that is Pena v. Horan, again, the microstamping issue in California. The next one we're going to go to Maryland, and that's Malpaso v. Palazzi. And that is a direct challenge to Maryland's requirement that applicants for concealed carry permits show a good and substantial reason to obtain a permit. See, under the Constitution, you're not required to show a good and substantial reason. However, court cases in the past have agreed that, as much as I hate it, they have agreed that a licensing system by a state, as long as it's reasonable, is okay. But showing a good and substantial reason is not reasonable. Okay, so that is one of the cases they're looking at, is how Maryland does its permitting process, Malpaso v. Palazzi. The next 3 cases they're looking at have to do with New Jersey. All right, and people in New Jersey right now are like, yay, somebody's looking at us. Rogers v. Gruel. I don't remember how he pronounces his name, but the Rogers v. Gruel case challenges New Jersey's May issue standard of concealed carry permits, in which the applicant needs to show a justifiable need that is more than just the simple self-defense requirement. So you saw Maryland, they're challenging one, and they're challenging in New Jersey. New Jersey's is tough. You might remember a couple of years ago the video I did when the New Jersey Second Amendment Society actually had somebody go in and apply for a permit at a police department, and they were wearing a camera, and that police officer looked like a buffoon, just violating people's rights, saying that they don't give out permits because of whatever reason. I don't remember the video at the moment, but they looked really, really bad, and that case is now before the Supreme Court. The next case from New Jersey that the Supreme Court is considering is Ciolek, or Ciolek. It's C-I-O-L-E-K. It's Ciolek versus New Jersey, and it's challenging the exact same thing that Rogers v. Gruhl is challenging, having to do with the may issue standard and having to show a good reason other than self-defense to have a permit. The third case in New Jersey they're looking at is Cheeseman versus Polillo. I believe it is Polillo. It is another challenge to the permitting requirements there. However, this one challenges New Jersey's ability to determine case by case if the applicant gets the permit based off of their reasoning. Again, Second Amendment says shall not be infringed. It doesn't say they need to have a good reason, and this person's good reason is not quite as good as that person's good reason. So you see the theme here with several cases challenging the permitting requirements in some of these states that are very anti-gun. The last two are here in Massachusetts, in this phenomenal Commonwealth. Gould versus Lipson is a case that is another challenge to the permitting process to an anti-gun state here in Massachusetts. You have to show good reason because it's a may issue state, it's not a shall issue, and this is challenging that, and I hope they win. And the last case, number 10, is the piece de resistance. This is the case that I am hoping they definitely take out of these 10. I hope they take a lot of them. I don't see them taking a lot. I hope they take this one, because this case, Werman v. Healy, would be able to, if they do what they're supposed to do, would wipe out assault weapon bans and stuff like that with a stroke of a pen. So Werman v. Healy is a huge case. If you watch this channel, you've seen numerous videos about how our Attorney General, Maura Healey, overnight changed the interpretation of a long-standing law in which Massachusetts citizens could purchase commonly owned arms, ARs, AKs, and things she calls copycats and duplicates. She just made this stuff up. And overnight changed it and made them illegal, unable to buy, and those of us who had them in the state were considered felons. However, she said that she might not, come after those people. Very, very totalitarian, very progressive, and very tyrannical. Maura Healey, the Attorney General of Massachusetts, she does a lot of this stuff. And a lot of the AWBs, or assault weapon bans, in the country since 2016 have direct language taken from her interpretation letter. So if they strike that down, that could be fantastic for everybody. So there you go. There are 10 cases before the United States Supreme Court for this Friday, May 1st, where they will be in conference, and I'm hoping they take at least one or two of these. You saw the theme is basically permitting issues, assault weapon bans, or bans on commonly owned arms, like the DC versus Heller benchmark says. So there are definitely cases that are in direct violation of the United States Supreme Court decisions. And also you have the will ban commonly owned arms by creating this technology that can never exist. Therefore, we can never sell a brand new gun in the state of California, or handgun. So that is what is going on Friday. Friday where I'm going to be. I'm going to be watching this from sunup to sundown. And then a little longer after that. So check this channel out. Hit the subscribe button down below. Hit that bell icon directly next to it. That will allow you to be notified of when I put out new content. There are 3 options now under the bell, so click the bell and select all notifications. Otherwise, YouTube picks and chooses which ones it sends to you. Also, if you could, please like the video. That has a huge play and a huge difference in how the video does and how many people see the video. it kind of forces YouTube's hand. If more people like the video, they show it more often. And also share this with your friends if you could. The more people that know about this, the better we are as a group, the Second Amendment group, the community we are. And we all need to start coming together as a community if we're going to win. And until we see each other again, be safe, stay vigilant, carry a weapon, stay tuned, because Friday could be a very newsworthy day. Take care, everybody.